You don't need a lawyer to represent you in court. It is nowhere written in the law, any books, any Bail Act that specifically says that only an advocate can represent a party. You can do it by yourself. You can appear as a party in person. You can file your applications as a party in person. You can argue on your behalf, so on and so forth. There are two aspects related to it. The first is because ignorance of law is no excuse. The courts and the legislative body and the executive body, everybody presumes that every citizen knows the law. So it is your obligation to know the law. Second, the only question many people ask me is whenever they approach the court, whenever they see the hearings, whenever they go through the proceedings, they attend the proceedings, they ask me, sir, I don't understand what the judge was saying. And they also ask me related to the proceedings, what are the steps that needs to be taken on the next date of hearing. And this is very, very technical in nature if you do not know the basic language of law, if you don't have any basic knowledge. So any layman is expected to know the law. So what is the other way around? There is no other way around it, for the basic reason, once there is a presumption against you that you should know the law, I suggest every layman, whether you are a businessman, chartered accountant, or just a farmer, you must know the basic principles which governs the law. You must know the concepts of law, and to some extent you also should know the sections which are there in the law. So there are two kinds of laws. First is substantive part. You are always expected to know that if you commit the offense of cheating, then you will be punished. If you commit the offense of murder, you will be punished. At the same time, if there is a case against you, or you have to file a case against somebody else, then at least you should know what is the procedure which has to be adopted by the court. So in this today's discussion, let's talk about the criminal courts. So criminal courts are three types. First is the judicial magistrates courts, second is the court of session, and third is the high court. And all these courts have to adopt a procedure whenever somebody approaches these courts. And that procedure has been laid down in the CRPC, whether it is the judicial magistrates court or the high court. If the trial is conducted in the high court, then the procedure would be defined by the CRPC. And it is irrespective of the fact that it is a narcotics case or just a simple check bounce case, or it is a case related to CBI or any state police. Apart from that, it is not just the procedure. Apart from that, there are certain powers of policemen which are given and laid down in the CRPC itself. For example, let's say police has to arrest somebody. Then the guidelines are provided in the CRPC. Who can be arrested? What are the steps which needs to be taken before the arrest? How the arrest should be made? What are the things which have to be kept in mind while some person is being arrested? Is there a provision related to the conducting the medical of the accused, the person who is arrested? There is a provision, like for example section 57 of CRPC, which says nobody can be kept in the custody of the police more than 24 hours without the order of the magistrate. So if the policeman arrests somebody and that person has to be produced before the nearest magistrate within 24 hours. It is irrespective of the fact that Delhi police people go to Karnataka to arrest somebody. In that situation also, when they make the arrest, they have to approach the concerned chief judicial magistrate or the judicial magistrate. They have to take the permission from the concerned magistrate so that they could bring that person to Delhi. Otherwise, if there is no permission, then the custody for more than 24 hours will be illegal. And these are the rights which have been given under the CRPC only. Now, let's assume one more thing. There is a presumption of innocence. So everybody is presumed to be innocent until proven guilty. So you are a presumably innocent person. And let's say police comes and they arrest you, they throw you in jail, they take the police custody remand, and then you are sent to judicial custody. Do you think that you should be punished without a due process of law? No. The answer is no. It will always remain no. Until or unless a person is convicted by a concerned criminal court. That that person always is presumed to be innocent. The other explanation to this would be that even if the FIR has been registered against you, even during the investigation, there might have been certain evidences which have been collected against you by the police. There might have been certain witnesses whose statement has been taken by the police. And let's say police has filed a charge sheet against you. Even in that situation, it will be presumed that whatever the prosecution is saying is just an allegation. It is not truth. It will become a truth only when the entire trial has been conducted, and that too as per law. Now, since the trial has to be conducted, there has to be a uniformity. If we go back like 200-300 years back, we will find that during those periods there was not a specified unified procedure for conducting the trial. Somebody accuses somebody, then the other person, if they have witnesses in their favor or not, there could have been different scenarios, there could have been different procedures adopted based on the religion, based on the caste, based on the status of the victim or the accused. But after independence, we have got a uniform code that for conducting the criminal trials, and that is called Criminal Procedure Code. Now, as a layman or as a law student, you would always think why we should know CRPC. Is there any other reason? And the reason is, when you go to court, 90% of the time in the criminal court, only the procedure is being followed. It is, the arguments are conducted on one date, 2 dates, and cross-examination is conducted on one date or the other date. But for most of the other parts, you will see there was an order which was passed by the criminal court on the last date of hearing. What has to be done on the next date of hearing, that is mentioned in the order. And during this entire trial, it is irrespective of the fact that the trial went on for more than 6 years, 8 years or 10 years, 90% of the time only the compliance of the previous order is being done. That means only the procedure is being followed. How the summons are being issued, how the witnesses are supposed to appear, how the chief has to be conducted, how the cross-examination has to be conducted, what are the applications which has been filed, whether the application has been supplied to the other party or not, whether the other party's lawyer is present or not, whether an adjournment was granted, whether the presiding officer was on leave or whether he is conducting the court or not. There are so many considerations, but 90% of the time you will see only the procedure is being followed. And this procedure includes how the FIR has to be registered. What are the powers of the police during investigation? Can you question the powers of the police during the investigation process? What are the conditions when the person can be arrested? What are the conditions, or what is the procedure adopted when the bail application is to be filed? When a person can be granted bail? What are the steps taken when the complaint is to be filed? How the summons are issued? How the file is transferred from one court to another? Where you are supposed to file the complaint? Which magistrate has got which kind of powers? And apart from that, you will see the other aspects also. For example, what are the orders which can be challenged in the superior court? For example, revision. What are kind of orders that can be quashed by High Court under section 482. So the CRPC is not a very big subject. It has got just 484 sections. Out of 484 sections, if you know the concept, then most of your problems are resolved. And if you know certain sections and their provisions by heart, then majority of the ambiguity that you have in your mind, that will be gone. Most of the sections are interconnected in one way or the other. And that is why I always tell people, whether you are a layman, a student or anybody, that you must know the law, because the legislative body and the courts, they expect you to know the law, and there is a presumption that you know the law as soon as it has been drafted by the legislative body. Now, this CRPC is based on the principle of due process. Let's also discuss one very important aspect, that is Article 21. Every person, just by being a human being, just by being a citizen of India, or just by being a person, has got certain fundamental rights. And first and foremost right is the self-preservation. That is called right to life. And second very important right is the right to have the freedom to live, to make your own choices. That is given under Article 21 of the Constitution. So every person has a right to life and liberty. And if this right was absolute, then anybody could have done anything. Anybody could have committed offenses. There would not have been any punishment for those people. But there is a condition attached to the Article 21 that this right to life and the right to liberty can be taken away by a due process of law, by a law established. Now, this CRPC is that due process of law. As we have already discussed, that if you commit murder, then you will be punished. You commit cheating, you will be punished. You steal something from somebody, then you will be punished. So this punishment is of two types. Whether it might be related to imprisonment, that they send you behind bars, or it may be death penalty. They take the life of the accused, the convict. In this case, you have seen in many cases the Honorable Supreme Court and different high courts, even session courts, they have awarded death penalty. So the person who has been convicted by a court after due process, his right to life or liberty can be taken away by the concerned court. And the court only directs the state government to incarcerate that person in jail during such and such period, or for such and such years, for so many years. Now this deprivation is based on the substantive law and after the entire trial has been completed. And if you go through CRPC and you feel that it is very technical in nature, if you feel that it is very complicated, mark my words, it is not. It is one of the easiest topics that you can actually come across. It is one of the easiest laws because it is mostly based on common sense. You don't need to cram any section, you just need to know the concept first. These sections will come later on, they will be handy, you'll be habitual, you'll know what sections say what kind of things. And the Honorable Supreme Court has already laid down certain interpretations of different sections, but mostly it is in favor of the accused. If you are being accused by the state, in that situation, CRPC is your only and first and foremost defense or safeguard that you have. If you have any questions related to it, you can ask me in the comment section. If you feel that this video is informative, then you can save it and you should share it with others also.